So good morning. Kara Fogarty with the Nonprofit Institute. And we have 14 people registered, but we just have 2 who've joined us so far. So I'm going to assume that maybe a few folks will join a few minutes late and they can just join at where we are. So thank you, Lydia and Randall, for joining us this morning. We are thrilled for today's class, Protect Your Organization's Hard-Won Assets. We have Sam Baldwin, Managing Partner with Baldwin, Briscoe, and Steinmetz. We also have Ann Murray, a CPA with Heim Lance. I think I said that correctly. CPA.
That's correct.
Okay. And Dan Burris with Old Town Insurance and other things. But we're thrilled to have them here today. I'm going to let each one introduce themselves. And then what we're going to do is we're going to spend some time with Sam on legal related issues. We'll take a break. We'll spend some time with Ann on accounting and financial issues, take another break. And then we'll hear from Dan about insurance topics. And, you know, at some point we may have a conversation. If you have any questions at any point, just throw them into the chat and we'll be sure to capture those. And I do have 2 more people who have entered the waiting room, so I'm going to let them in if I can find them. There they are. So what I'll do is I'll stop sharing this right at the moment and we'll let introduce himself and then we'll go to Ann and then to Dan.
Ann, you want to go first?
Oh, okay. My name's Ann Murray. I'm a CPA with Heim Lance, CPAs and advisors. I was originally had my own firm with Jenny Walmsley and Kathy Schrader. It was Murray, Walmsley, and Schrader. And in 2019, we merged with Heim Lance and we became their Southern Maryland office. Their main office is in Annapolis. And I have been involved with nonprofits my entire career in different capacities, both from sitting on nonprofit boards to auditing and tax services and advisory. So I'm very familiar with the nonprofit area of that you all deal with every day. And I look forward to speaking with you today.
Dan Burris. I'm with Old Town Insurance Agency here in Leonardtown, certified insurance counselor. I've been in the insurance business, well, as of June 4th will be 40 years here in Leonardtown. I was with another agency for 19 years and had the opportunity to go out on my own in 2000, representing mainly Erie Insurance Group. I am an independent agent, number of companies, but probably 95% of our business does go to Erie. So we do have a number of nonprofits that we do write coverage for currently, and just glad to be with you, and hopefully we'll get some good information out to you.
Right, that leaves me. I'm Sam Baldwin. I'm the managing partner of Baldwin, Briscoe, and Steinmetz. It's a law firm located in Lexington Park. We've got about 9 attorneys. My background is undergraduate at UVA, did some work at University of Chicago, law degree from University of Baltimore in '84. Our law firm does a lot of different work, but very little with nonprofits. However, that said, most of us in this firm have served on nonprofit boards. I've been president of the nonprofit Historic St. Mary's City Foundation, currently president of the nonprofit Leadership Southern Maryland. My wife has served as president of the board at Historic St. Mary's City, Historic Sodderly. And like Ann, and probably like Dan, I've done a lot of volunteer work for different nonprofits over the years, teaching at Riken, teaching at St. John's, and of course, other things, volunteering at St. Mary's. So volunteering at St. Mary's, volunteering at Sodderly. So the topics we're going to discuss are specifically geared towards the nonprofit organization, but a lot of what we're going to discuss would apply to any organization, nonprofit, for-profit. And while I myself don't get involved in setting up nonprofits, I deal, as a nonprofit board president, I deal with accountants regularly. I know that when we have an accounting issue, it's the accountant that we have to reach out to for their specialty. When we, there we go. When we deal with insurance matters, it's the insurance agent that we reach out to because he's got a specialty. My specialty is litigation. And so much of what I'm going to be talking about is the protecting side of it. Where is the risk when it comes to litigation, whether it's to the organization as a whole or towards the members of that organization, board members, volunteers associated with the presentation. So if we can have the next slide. This next slide is going to be a quick one because my associate is a stand-up comic. I asked him to prepare this slideshow, and this was his idea of how we start. There you go. Put everything in an untraceable bank account in the Cayman Islands. Ba-da-ba. Okay, let's go to the next slide. Okay, so there's more to this slide, but focusing on this right here, get it in writing, save a copy. When you deal with an accountant, for instance, and Ann Murray will talk about this, she's going to need to see the documents. She'll explain why. When you deal with your insurance agent, these policies are going to be documents. Get those documents, save them. Receipts. Receipts show your expenses, obviously. You're going to need those for the accountant. Ann Murray will talk about that. Contracts. If you're doing a fundraiser, if you're doing, you're hiring somebody to do repairs to your building, your facilities, there's going to be a contract. If there's anything somewhat confusing that you're not sure of, run it by an attorney. Plain English language doesn't always apply in a courtroom. There can be terms of art that have different meanings than what you think. So if the attorney doesn't draft the agreement, let's say the person you're dealing with has drafted your agreement, have an attorney to take a look at it. Indemnity clauses. Dan Burris is going to talk about this a lot more because of the insurance side of it. But from a lawyer's point of view, is there something in the contract that says, I am not responsible for this, or you will be responsible for that? Waivers are related to that. Have you signed anything in the contract waiving liability, waiving responsibility? These contracts can be lengthy, complicated. Dan Burris is going to show you probably 16 pages of contracts later today. Have somebody like a lawyer read them. Ideally, when you put together your nonprofit board, you may have a lawyer on that board, or you may have somebody who knows a lawyer. I know with Ms. Fogarty, with the Nonprofit Institute, we were talking about lawyers who will be available pro bono, whether it's through Leadership Southern Maryland or just in the network at CSM. Somebody who can volunteer to help your nonprofit out, to take a look at the contracts. So everything I said about your contracts would apply to their contract. Read it, have a lawyer read it. Make sure you understand your risks, your responsibilities, your exposures when you're dealing with those contracts. All right, so if we can get the next slide, which is who has authority? Well, focus on the word who. Your nonprofit has an executive director, for instance. You may have a board with a board president, a vice president, a treasurer, a secretary, members of the board. Then you talk about, if you look at the first two words, an agent. An agent is not only the people who directly work for the nonprofit, the people I just mentioned, executive director, board members, et cetera, but volunteers. You have staff people who are agents for your nonprofit. You have volunteers who show up on the weekends or an as needed basis. They are your agent. So An agent's authority must come from the principal. The principal might be the executive director, who has authority to run the day-to-day operations. It could be the board president, who is maybe running a committee on the board, whether it's finances or volunteers or whatever that committee may be. You have different principals, and the principals are in charge of the agents associated with that committee. So it's well established that the authority conferred upon the agent by the principal can take two forms. Actual authority. The agent, the principal, board president, executive director, says to a volunteer, this is what I want you to do, or they put it in writing. This is what I want you to do. That is actual authority. Apparent authority would be something like, can you run this program? But I'm not going to give you specifics, but I know you're going to do it. And I'm not going to restrict your actions, and I'm going to get the benefit of your actions. So that's apparent authority. And we refer to the first case, Progressive Casualty Insurance. And I mentioned to Dan Burris that a lot of the cases I'll be talking about have to do with insurance. We've got to go back. Yeah. So when you're a lawyer studying the law, learning the law, you deal with cases, because these cases that might start in the district courts and go to circuit court and then go up to Annapolis to the appellate courts, you have a factual situation. Somebody gets hurt. Somebody files a lawsuit. How is it decided at the county level? And if there is a mistake made by the judge, it goes up to Annapolis. But these cases are helpful to lawyers and helpful to all of us on the screen, because we can see a factual scenario, and then we can think, how would the factual scenario in Progressive Casualty Insurance, for instance, apply to my situation? So Progressive Casualty was a motorcycle accident. Progressive Casualty provided the relevant insurance coverage. They didn't want to pay. They said, well, we're not liable. And the reason was, in part, the person in the accident let their insurance policy lapse. So let's say the policy lapsed, and Mr. Burris will explain this later, but it lapsed on a Monday. When it lapses, you're given a week to pay your premium, and then it's reinstated. By definition, in the fine print of the policy, it says, when you give me a check, we reinstate that day. But the practice apparently was, in this case, we're going to backdate the reinstatement. The reason insurance companies may willingly backdate a lapsed policy is, let's say they backdated a week. The assumption is nothing happened during that week, so we've now given this insured person one less week of coverage. Only in this particular case, during that 1 week, person got into an accident. And so the insurance company was trying to say, hey, our contract says we didn't cover you until you paid your premium. But because their insurance agent had backdated the coverage, that was an agent who bound the insurance company. And you get into the actual authority may be what was in the contract. The contract says your actual authority is you reinstate when we get payment. But the apparent authority is, in the business, we regularly backdate and we look the other way. So what happened was Progressive Casualty ended up paying this for this accident, even though it happened during a lapsed period, because the apparent authority Progressive gave to their agent was, we're going to let you backdate. Dan, am I right?
Okay, unmute it now. Yes. It's up to the company as to whether when they're going to backdate it. An agent doesn't have the authority to go back. It's up to the company themselves. Now, on an agency standpoint, yes, we are part of Progressive. I'm a Progressive agent also. We represent Progressive. We don't represent the insured as an agency. But yes, Progressive would be the one that agrees to go back to that date. Now, a lot of times they will require something from the insured saying that there have been no claims before they will do that.
Here's what the court said. The court said an agent's authority to act must come from the principal. So Dan Burris's authority to act has to come from Progressive. The authority conferred upon the agent by the principal can take two forms. Actual authority, meaning it's in writing. Dan Burris, Progressive allows you to do this. It's in writing. However, apparent authority is the authority which, though not actually given to Dan Burris, for instance, by Progressive knowingly permits the agent to exercise. So, applying that to the nonprofit, you have actual authority that you give to your volunteers. This is what we want you to do. It's in writing, or you have an office policy manual written. That's the actual authority. Apparent authority comes in when you know your agents or your employees or your staff or whomever are doing things differently. You know it and you're not correcting it. So that's the first thing that as if you are listening as a board member or an executive director of a nonprofit, you have to know that distinction. So then we talk about the next case, which is the agent's function is to represent the rights of the principal. Dan Burris, as insurance agent, has to represent the rights of Progressive. Your staff members, your volunteers, they have to represent what you as an organization want. The agent, your staff members, your volunteers, their authority is limited by the instructions, restrictions, and needs of the principal. The principal is your agency, your nonprofit. And the reference is made to this Walton versus Mariner Health of Maryland. In this particular case, the agent was the grown child of a disabled adult, an elderly adult. Mariner Health of Maryland is a nursing home in La Plata, or was a nursing home in La Plata. So Walton was the daughter. There was Walton and Walton, actually, Mom Walton and daughter Walton. Walton and Walton and the nursing home. The agent, the daughter, signs Mom into the nursing home. There is a written contract between the nursing home and the agent, because mom cannot sign the contract. The contract says daughter will process papers so that Mom can get Medicaid or Medicare coverage. That's the way it works. I guess Mariner Health was in the process of selling their nursing home. I don't know what was going on in their billing department, but you have to renew Medicare or Medicaid. The daughter didn't know that. The daughter didn't do that. Mariner never instructed her to do that. So it went about 10 months or so where Mariner wasn't being paid. Mariner has two choices. We can sue the mother who's living in the nursing home to try to get this $48,000, $50,000, but mother in the nursing home has nothing. So we're going to sue the daughter who was the agent because maybe she can pay the $50,000. Well, the contract Mariner had with the daughter specifically said, daughter will not be liable for mother's bills. Daughter is simply signing as the agent. Mariner went after the daughter, basically saying, daughter, you had an obligation to renew Medicaid or Medicare. You didn't do it. That makes you liable. Incredibly, in my mind, the circuit court judge in Charles County held the daughter liable. Said, daughter, you are liable for $50,000 of your mother's bills because you didn't renew the Medicaid, Medicare. Then the judge tried to have it both ways. He said, but I'm not going to enter a judgment against you. I'm going to hope that you two can work this out, do some kind of compromise. Daughter said, essentially, well, I'm not going to say what I would have said, but daughter appealed it and won. And of course, the appellate court reversed. Now, the agreement between the daughter as an agent, and the nursing home was 30 pages long. That's coming back to have a lawyer look at these documents before you sign them. Even if you're a nonprofit, even if you're the agent. What the court said, the daughter had a primary duty to her mother, not to the nursing home. The daughter had a very limited obligation towards the nursing home. So going back to my PowerPoint, the agent's function is to represent the rights of the principal. Your volunteers, let's say you're doing a fundraiser. You've got three groups involved. You've got the nonprofit, who would be the principal. You've got your volunteers and staff, who are the agents. And then you've got a third group, whether it's let's say a vendor is coming onto your site to sell goods for a fundraiser. Your volunteers, they represent your rights. They do not protect the rights of people coming onto or that you're dealing with. The agent's authority is limited by the needs of the principal, not by the needs of third persons. The daughter in this case, her responsibility was to the mother, not to the nursing home. That's how this particular case would be relevant to you. So when we look at the intro to this PowerPoint, who has the authority? It starts with the nonprofit organization itself. Comes down to the executive director, members of the board who may be running committees, flows down to your staff and your volunteers. So can we have the next slide? Types of authority. And we've pretty much already talked about different types of authority. Is it in writing or is it apparent, implied? Actual authority is could be expressed, could be implied, but it's very clear. This is the authority I'm giving my employees. This is the authority I'm giving my volunteers. By the way, I keep referring to volunteers because even though they may not be paid members of your staff, they may not be on the board, nonprofits live and die with the strength of their volunteer group. And later in this presentation, I'm going to talk about statutory protection specifically for volunteers. Volunteers are your agents. So the apparent authority, it may not actually be granted. Danny Burris already talked about Progressive maybe actually giving him authority to backdate or not. That case law that I recited, the insurance company there maybe allowed backdating or maybe looked the other way. That's apparent authority. The principal, whoever you're dealing with, or whoever it is in your group, we know what our agents are doing. So one who knowingly permits another to act for him as though authorized, inducing third persons to rely to their disadvantage on seeming authority, cannot later assert, hey, you didn't have the authority to act on my behalf. That brings us to, on this PowerPoint, reference to yet another insurance case. Reserve Insurance Company versus Duckett. In this particular case, it was a motor vehicle accident. And the question was whether Reserve Insurance Company had any obligation to provide insurance. This is the Reserve Insurance Company is sort of like, again, Danny, I keep using you as an example, but let's say sort of like Dan Burris Insurance. He did not have, Reserve Insurance was not an authorized agent for, or the local insurance company was not authorized for Reserve. But the local insurance agent wrote policies for Reserve, stamped his name, let's say Dan Burris, I'm the agent for Reserve, sent it in with a check to the insurance company, and the insurance company took the check. So there was a pattern where Reserve didn't authorize this particular agent to write policies, but when the agent did write policies, Reserve granted the policies, renewed the policies, took the check, sent out renewal notices, et cetera, et cetera. Reserve Insurance Company got the benefit of the work done by an insurance agent, let's say in Leonardtown. And
Sam,
then when,
if I could just interrupt there for a second. Sounds like it's more of a brokerage agreement rather than an agency agreement. Under a brokerage agreement, I am a broker also, not just an agent. When I go out to other companies, I'm doing that as a broker, and I'm not representing the company. I'm actually representing the insured.
and that's said far better than I could have said it. But the point is, what happened in this case is the insurance agent, or the insurance company, whether it's State Farm or Progressive or Nationwide or whoever it is, when they get a policy and a check and they have a new insured, they're going to take that policy and they're going to take that check. They can't later say, oh, by the way, this local agent or broker wasn't authorized to write for us. We don't have to cover it. I'm not going to go into any more facts of the case, but how does it apply to your organizations? It's the same thing. You've got staff members who are on the staff. They're part of your list of employees, your paid employees, your board of directors. You may have people who regularly show up at your fundraisers or your community events. They're not on the payroll. They're not on the board, but they're acting on your behalf, and you want them to act on your behalf. They help you run your programs. If something goes wrong with respect to that person, you're not going to be able to say that person wasn't acting on our behalf. There's going to be a lawyer somewhat like me saying, oh, yes, he was, because this is the pattern. And then you're going to have to go to somebody like Dan Burris, the insurance agent, and say, are we covered? So that's the apparent authority side of it. And so the last part of this slide, the key question is reliance reasonable. And so with a lot of the law, it's a reasonableness question. If you know somebody is acting on your behalf, if you know this is how they're acting on behalf of your nonprofit, and if the public knows this particular person regularly acts for your nonprofit, the public reasonably relies that whatever that agent is doing is by apparent authority given by the nonprofit. So I think the ratification is pretty much covered by the last couple of cases that I've talked about. Any limit placed by the principal, your nonprofit, upon your agent's authority, agent being staff, employees, volunteers, limits you place on those people may be ineffective if you know what your agent is doing, authorized or implied, and you waive the act. You basically look the other way. You let the agent act for you in exceeding his authority. You're going to have liability. This Hill versus State was an interesting case. I won't go into it too much, but the negligent person, if you will, was a circuit court judge. Hill was an inmate convicted on a crime of violence. And let's say he was convicted in years before this case, and he was sent to jail. And under the terms of the criminal statute that applied when he went to jail, he could have served so many years, and then he could have been sent to a treatment facility for substance abuse. That's the way it would have worked. The circuit court judge misread the statute. The circuit court judge left Hill in jail for so many years to, let's say, teach him a lesson, and then said, but I will let you go to this rehabilitation facility after you've done so many years in jail. Well, what happened is, while Hill is in jail waiting to get into the rehab, the legislature in Annapolis changes the law in such a way that Hill will no longer be authorized to go to the rehab. Hill appealed it, and he said the judge screwed up. The judge misunderstood the law, kept me from going to a rehab facility, And now I, Mr. Hill, am being sentenced more harshly than if I'd just been sentenced the right way when I first got convicted. The circuit court judge was the agent working on behalf of the principal of the state. So limits placed by the state upon the circuit court judge are ineffective if knowledge of the facts. You'd expect the judge to know the facts. And the judge, he didn't really exceed his authority. He didn't exercise his authority. So in this particular case, even though the legislature said, we've changed the law, Hill cannot go to rehab, they let him go to rehab. They did the right thing. Coming back to you and how it applies to your nonprofit, any limits you put on your agents are ineffective if, once again, you allow the agent to act on your behalf in excess of the authority that you've given. Yes, once again, you as an executive director, president of the board, whatever, you have to have an intention to ratify what your agents are doing. You have to know what your agents are doing. Those two elements are somewhat common sense. Before you can be bound by what your agents are doing, you have to know what your agents are doing. You have to know that the local insurance broker is writing policies, sending in checks, and you're taking. You have to have that knowledge. You have to have an intention to ratify. If you're the insurance company, you take those checks from the local broker. You issue the policies. Okay, ratification. So can we have the next page? I think we're somewhat becoming repetitive now. The intention to ratify may be inferred either by explicit words, I allow you to do what you're doing, conduct, I'm letting you do what you do, or silence, I'm saying nothing. So what that's saying is, as the executive director of the nonprofit, as a committee chair, whoever it is in authority, I know what my agents are doing, and it is fine with me whether it is technically authorized or unauthorized. This Linden Homes case is interesting in a interesting respect. You had two groups of people who were exactly the same groups of people, but one corporation bought the land, which was barren land. The other corporation built homes and sold the homes. The two groups of people owned both corporations, but one side of it bought the land, one side of it built the homes. So one side of it takes out let's say a $500,000 loan, but obligates the other side to pay it. And the question is, when you have two corporations, the same presidents, et cetera, can one corp bind the other if the other court doesn't know, or the other corporation? So the intention to ratify, what are the words? What are the conduct? Is there silence, et cetera? The answer to this particular question is, you could not bind the second corporation by what the first corporation did. You've jumped the gun there. But now we go on to the rest of the story. The second corporation, which didn't sign that $500,000 note, they got the benefit of it because homes were built, homes were sold, and they're the same groups of people, so they shared the profits. So even though it was an unauthorized transaction, because they got the benefit of it and they didn't disaffirm what they learned about, both corporations became liable. Once again, how is your nonprofit made liable for something done by your agents? Did you receive a benefit from the agent? The agent went out and, let's say, in an unauthorized way, raised some money on behalf of your nonprofit. Well, you say, well, who's this agent? Where's this money coming from? But thank you very much. We will keep that money. the thought that comes to mind, because I am a litigator, let's say somebody induced an incompetent person to write a check for $10,000 to your nonprofit. You take the $10,000, even though this isn't an agent. We don't know how they got the money. You've taken the $10,000. You're probably going to have to give that $10,000 back if you're made aware that it was done improperly. Okay, so I've talked about how you can be sued as an organization, but now we get to the good news, which is the legal protection for nonprofit volunteers. And this, once again, is going to tie in a different way with the conversation from Dan Burris, the insurance side of it, because there are obviously insurance protections. But what I'm talking about here is usually when there is no insurance. What is the protection? So let's see here. We have two sources. We have a federal source and the Maryland source. Let's start with the federal source. And I refer to the Federal Volunteer Protection Act. I did not provide the federal act as a PowerPoint, but I'll give you some of the language. And once again, it's common sense. This act may be cited as the Volunteer Protection Act of 1997. The U.S. Congress finds and declares that, now this language will apply to all of your nonprofits, the willingness of volunteers to offer their services is deterred by the potential for liability actions against them. Who's going to volunteer if they're going to volunteer to be sued? As a result, many nonprofit, public and private organizations and governmental entities, including volunteer associations, think somebody helping out with the library, somebody helping out with EMS or fire department, and other civic programs have been adversely affected by the withdrawal of volunteers from boards of directors and service in other capacities. And once again, if you're on a volunteer board, the question is, what if we get sued? If you're volunteering at a fundraiser, what if we get sued? Congress went on to say that the contributions of these programs to their communities is thereby diminished, resulting in fewer and higher cost programs than would be obtainable if volunteers were participating. So they talk about high liability costs. A lawyer is going to sue you. They talk about higher insurance costs, unwarranted litigation. So Congress made it clear that a volunteer acting within the scope of his responsibilities in a nonprofit organization or government entity at the time of the act or omission, the failure to act, you're not going to be sued for that. The important language is you're acting within the scope of your responsibility. The volunteer is doing what you have instructed them to do. They are doing what they are authorized to do. They are not doing unauthorized acts that are reckless or hazardous or negligent. So this particular federal act protects the volunteers. It does not protect the organization. Now, what we have is, they talk about nonprofit organization in this federal statute. Any not-for-profit organization which is organized and conducted for the public benefit, which is basically all of you, operated primarily for charitable, civic, educational, religious, welfare, or health purposes, all of you that are attending today, is the nonprofit organization. And so volunteers for your organization are protected. Now, the federal statute provides broader protection than the state statute. So what the federal statute says is, if your state statute only gives you this much protection and, a little bit, and the federal gives you greater protection, the federal statute applies. But now we have the Maryland Volunteer Service Act. And they talk about, the act applies to charitable organizations, which includes your nonprofits by definition. They talk about the volunteers would be an officer of the organization, a director, a trustee, volunteers, somebody who works without receiving compensation. And it provides protections as long as what you're doing is authorized. Whatever you're doing is not negligent or reckless, or intentionally what we call tortious, intentionally meant to harm someone. So what do we have on this PowerPoint? Protection to volunteers comes from the two sources I just talked about. Volunteers are generally not responsible for harm or injury if they act in such a way, which we just talked about. Liability is generally limited to the personal insurance the volunteer has. So what that is saying is, if a volunteer is going to be sued, somehow the volunteer falls through the cracks, the volunteer's exposure to liability, to costs, is going to be limited by whatever insurance they have, assuming they have insurance. And then, of course, we talk about at the bottom of this screen, volunteers can be liable if they commit a crime and so forth, violate federal laws, under the influence of drugs or alcohol, things that you don't want your volunteers to do anyway. And if you're running a program or a fundraiser or whatever, you're not going to have that volunteer on the premises if they're committing crimes or under the influence. So there's your protection. Now, the next slide, officer and directors as volunteers. The statute defines that, yes, officers and directors are volunteers. They have that protection that we just talked about. Of course, the state, if the state wants to sue you, they're going to sue you. The state does not generally write laws that keeps them from doing whatever they want to do. So now we're talking about liability that your nonprofit might have, not the volunteers, not the individuals, but the organization. And you could be sued because of something done by one of your volunteers. The volunteer may be protected. That doesn't mean that the organization is always protected. Now, there is something called the charitable immunity rule, and I'll go into that in a little bit more detail. But the charitable immunity rule basically says, if the assets of your charity, you have $100,000 in the bank, if that money was raised by donors, given to you to provide, whether it's housing for the homeless, food for the hungry, educational opportunities for people who aren't getting it in the public school system. If that money is raised or given by donors and earmarked for your program's operations to the public, that fund is off limits to anyone suing your group. On the other hand, and if you have no other assets, a lawsuit's not going to do any good. You've got charitable immunity. On the other hand, if you have liability insurance, you go to Dan Burris, you have liability insurance. I'll let him talk about this in greater detail. But the insurance company cannot say, hey, because you can't sue the Center for Life Enrichment, because you can't sue St. Mary's County Public Library, you can't sue because of charitable immunity or whatever. You can't go after the insurance company. And case law seems to say that if you choose to have insurance coverage, that insurance coverage is in play. The insurance company cannot raise the charitable immunity rule. Let's see, can you bring down the next? Okay, so yeah, must be a charitable institution. We've talked about that. Donors gave the funds for charitable purposes, feeding the hungry, housing the homeless, educating people who aren't getting the education in schools. But if there is an insurance policy, charitable immunity does not apply. Can we come down one more? So we're talking about a couple of cases, James versus PG County. James was in a motor vehicle and was T-boned by a volunteer rescue vehicle. Volunteer rescue vehicle, a volunteer fire department truck. Allegation was they were negligent. You know, that's an allegation, doesn't mean it was true. The volunteer fire department said, hey, we have charitable immunity because we're a nonprofit charitable status. That is the first thing that each of you would say if somebody tried to file a suit against you. We are a nonprofit. We are subject to charitable immunity. Your insurance company, if you have insurance, would probably assign, and Dan Burris can talk about this, but they would probably assign a lawyer to represent you. And the lawyer defending that lawsuit, one of the first things they're going to say is charitable immunity.
Hey, Sam?
Yes.
This is Kara. Randall had a question, wanting to know if what you were talking about a moment ago included restricted funds.
Well, it depends. Okay, so restricted funds would probably be similar to dedicated funds. I mean, a lot has to do with where the funds come from, how you get those funds, and how you apply those funds. So, you know, it almost certainly is fact specific to those questions. And what I'm trying to do is generalize to all the nonprofits that I know are on the board. But if those funds are for a charitable purpose, and I'm going to talk about that in this case law here, most likely those funds are not going to be taken. But I'll offer this. It's once again a common sense position that the courts are taking. These funds have been given to you by members of the public, not to settle lawsuits, not to pay out a liability claim. These funds have been given to your nonprofits by members of the public so that you as a nonprofit can serve charitable purposes. So that's why the law protects those funds, because it defeats the charitable purpose if your dedicated funds can go towards a lawsuit. So here's what, in this fire department case, here's what the court said. The mere fact that the fire company is a nonprofit corporation does not mean that it is entitled to charitable immunity. All right, you're a nonprofit. Your attorney's going to raise charitable immunity as a defense. Doesn't mean it's going to work necessarily. The court goes on to say, it is well settled that charitable immunity in Maryland exists and is founded upon what has come to be known as the trust fund theory. So whether that trust fund theory applies to restricted funds or dedicated funds, here's what they go on to say. Damages cannot be recovered from a fund held in trust for charitable purposes. For to do so would not be to apply it to those objects whom the author of the fund had in view. If you created a fund specifically to serve public charitable purposes, and you put money in that fund specifically to carry out these charitable purposes, the state of Maryland does not want those funds going to cover liability because that defeats the purpose of it. Only, this is what they go on to say about charitable immunity. Only when the assets of the charitable organization are held in trust, either expressly, I've got a trust fund expressly for housing or feeding or education, either expressly or by implication. We set this fund up years ago. This is where we raise the money for feeding people. These are the food banks we send it to. And when the corporation has no liability insurance covering the act, that is when charitable immunity applies. So I've sued a nonprofit. All of their funds are in a dedicated fund. They have no other assets. The nonprofit is immune from suit. On the other hand, all of their assets are dedicated to serving charitable purposes. But by the way, we do have a policy through Dan Burris. Now the charitable immunity does not apply. But keep in mind, what we're saying there is the lawsuit can proceed against the nonprofit, not against your volunteers, not against the board of directors, not against the executive. It proceeds against the organization only to the extent that they have insurance coverage. So this next case, Abramson, judges sometimes have fun with these cases. This is how this opinion starts. A broken nose suffered in a basketball game has ballooned into a request that Maryland's century-old charitable immunity doctrine be judicially abrogated. The court would not allow the lawsuit. In brief, it was a pickup basketball game at the Jewish Community Center of Greater Washington. Jewish Community Center has a basketball court. People show up at that court. They're having a pickup basketball game. Somebody's a little aggressive, breaks somebody's nose. Jewish Center got sued. The question was whether the Jewish Community Center had, first of all, whether they had liability insurance, and if they do not have liability insurance, can they be sued, or do they have charitable immunity? The director of the nonprofit, the Jewish Community Center, said that the net earnings of our center are always reallocated to the organization's programs and services. That kind of touches upon the earlier question about dedicated funds. What this director is saying is, the only money we have, we use it to serve the community. The executive director also said, by the way, we do not have insurance. They were uninsured. So the court concluded this case about the broken nose on the basketball courts of the nonprofit Jewish Community Center by saying this, that the Jewish Community Center is an uninsured charitable institution whose assets are held in trust in furtherance of its charitable purposes. The charitable immunity doctrine applies and they cannot be sued. So there you have it, a nonprofit, their money goes to serve public purposes, which again, I'm going to assume just about everyone on this screen would be in that position. Your volunteers are protected by federal statute, by state statute, and the courts are not going to allow you to be sued if your funds go towards serving public charitable needs, and you have no other assets. So can we go on to the next slide? And this is where I start wrapping it up. And look, Danny Burris, contact your insurance company right away. If you have a problem, somebody has made a complaint or whatever, contact your insurance company if you have insurance coverage. Your local agent's going to tell you, by knowing your policy, by knowing your organization, whether you're covered or not. If there's a lawsuit, your insurance company is probably going to give you an attorney. If you don't have an attorney, your first step might be to come back to Kara Fogarty at the Nonprofit Institute to see if you can get a volunteer attorney, somebody like me, or somebody else who's with Leadership Southern Maryland, somebody who's willing to give you an informal, quick advice. This is what you need to do. And if you contacted me first, I'd probably say, do you have insurance? Contact your insurance company. They're going to protect you. If you get a letter from somebody who's filing suit, somebody who says, hey, I broke a nose on your basketball court. I slipped on a banana peel at your stuffed ham meal, whatever. Don't respond to them. Don't go to the public. Don't put anything on social media. You want to talk to your insurance agent. You want to talk to an attorney. Yeah, so you've lawyered up. Okay, well, you've talked to me. tell me what I need to know. These cases, there are fine points in these cases. Where do you get your money? You know, what are your assets? Who was running that basketball game? Who was supervising? If you're selling beer at a fundraiser, were you carding people? Did you have any way of knowing whether somebody was legally able to drink? Did you know somebody was intoxicated and you kept selling beer to them? You know, I need to know everything so I can give you good advice. Let's see, follow my advice. Okay, so I give you advice. You may not like what I tell you, but it's my job to tell you the risks, where the risk comes from, why the risk is coming from this point or that point. And again, I'm likely to steer you to your insurance agent to find out what kind of coverage you have, assuming you have coverage. If not, you know, I'll do the best I can, or maybe find somebody who can help you. Oh, life cycle of a lawsuit. Well, it starts with complaint. Frankly, the life cycle of a lawsuit, let's use that basketball court. You're running a pickup game on your basketball court and you know somebody got injured. Right then and there, you know there's very possibly going to be problems. All right. Then you get a letter from either the person that got the broken nose, or you get a letter from their lawyer. All right. It's not a complaint yet, but it's moving in that direction. If you know of the accident, you may want to talk to your insurance agent. If you get a letter from the person with the broken nose or the lawyer, you definitely want to talk to your insurance agent and a lawyer. And then, of course, once a complaint is filed, then it's definitely in the hands of an insurance, whether it's the insurance company attorney or somebody like me. And all this other stuff is pretty much things that you trust me to get right, just like Ann Murray. I can bring her in on this. When you're talking about financial, you know, the books and the audits and the tax returns, I don't know anything about that. I know it's very complicated, and I know Ann Murray takes care of that stuff. So when you see answer, discovery, motion, settlement conference, trial, just leave it to your attorney to explain that as it happens, if it happens, because it can be very complicated and overwhelming. Once again, discovery process, interrogatories, documents, admissions, depositions. This is more stuff that we deal with if it becomes a lawsuit. But interrogatories, just to give you a heads up, interrogatories are formal legal questions, and you may get these questions half a year. It could be 3 years after the accident. That's why at my first slide, it's like, keep records, keep receipts, because if there's a lawsuit 3 years after the incident, there is a 3-year statute of limitations. You're going to have a way of remembering what happened, who were the witnesses, who were my staff people, what kind of literature did I post online about this fundraiser or this event? That will be relevant if there's a lawsuit. Yeah, and discovery is key. It helps both sides evaluate the case. And frankly, I'll just say this about litigation. The better prepared side is generally going to have the upper hand. If you've kept good records, you're going to be better situated to handle a lawsuit that may come up 3 years after the fact. So keep those records, give them to your attorney, and then let him do, or let me do, whoever it is, what we do best. Okay, next one. Settlement discussions. Truth is, most of these lawsuits do settle. Part of the reason they settle is by the time it gets to trial, both sides should know the documents they have, the evidence they have, how that evidence fits into the case law. The cases like the broken nose or the car crash or the insurance coverage case that I read. We take the facts of your particular case, whatever it is that happens to you, And then we look for the case law. How does the case law apply to the facts of your case? And once we know that, it's usually a done deal. You know, we know where this case is headed. And so, you know, if you have the insurance coverage, the insurance company is going to tell you, hey, this is what we're willing to do. Timely paying judgments, let's hope it never, ever comes to that. As a defense attorney, I never want to tell my clients about paying a judgment. My clients don't get judgments against them. We're not going to go there. That's pretty much my presentation. I see that it's about 5 minutes after my time. Does anyone have any questions? So far, I don't hear any.
Yeah, someone in the chat said that they appreciate the reminder to keep documents, make contemporaneous notes. In the moment, you think you'll remember all the details, but that's not at all what happens. And this is really important advice. Other folks have said thank you. And we'll be able to share this presentation with the participants, Sam?
Great, yes. And I'll just say this, and then I'm going to sign off. But, you know, keeping documents, if you have a lawyer and you run a document by the lawyer, even if you don't keep that document, generally speaking, your lawyer will. He'll keep a file, even if it's just a consult. Somebody like Ann Murray, who's doing your audits and so forth, your tax returns. Those are documents that may be relevant. They give you names, they give you reminders of the fundraisers, the source of funds, and of course your insurance agent. You know, in writing a policy, he's going to have a file on you, and that may, I'll let Dan talk about this at his part, but that may have background information. We're insuring an event you're running, we're insuring your organization, and so forth. So the different groups that you deal with professionally will also have those documents. If there are any other questions, feel free to shoot me an email. But thank you for participating. Shout out to Amy Ford, fellow graduate from LSM. And any other, thanks, Sam. Yep.
Thank you, Sam. We really appreciate it a lot. If it's good for everyone, should we take just maybe a 5-minute break? Come back at about 10:12. Just give everyone a moment to stretch and refill their coffee. And we'll continue with Ann Murray. Thank you. Okay, we are back. And that was a great presentation from Sam, a lot of good detailed information, and we will get that presentation to you. We send out a follow-up email after the class, probably this afternoon, at the latest tomorrow. And that will also include the presentations, a survey, like an evaluation. And some of you may need a certificate, and we can get those to you as well. And so we'll send that out. But now we have Ann Murray. She's a CPA, and she's going to share with us some information about financial and accounting related concerns for nonprofits. So thank you, Ann.
I had to unmute. Excuse me. Thank you, Carol. I'm going to share my screen here. So when I was asked to participate today, and I was told the topic, protecting your organization's hard-won assets, you know, right away I think about legal issues or insurance issues. You know, how do you protect assets? You need to have good contracts in place. You need to protect, you know, with your people, with agreements, employment agreements, and of course you need to have insurance. But then I started thinking about, you know, a nonprofit, their greatest asset can be their reputation. And how do you protect your reputation and your place in the community? And you have to do that through compliance. And there are so many things to comply with being granted the status of a nonprofit organization. And that's where I'm going to take you today. That's my expertise. So that's where we're going to go. So, you know, back when you were granted tax exempt status, it's like, that's a great achievement. Congratulations. And you don't have to pay taxes. Well, not exactly. There are certain taxes you're still going to be responsible for. There's many types of information reports that you must file. And being a tax exempt organization, you have to comply with the requirements There's certain activities that are prohibited. There's ways you need to raise funds and take care of those funds. And so that's what I want to talk about today. What could go wrong to jeopardize either your tax exempt status and losing that, which unfortunately I've seen that, or just not having the best reputation, and you want to protect your reputation, absolutely. So there are 3 general activities that you could lose your tax exempt status, because these are ones that are either prohibited or you have to be careful how much you're doing in that area. So the first thing we're going to talk about is private benefit or inurement. And this is kind of like, they sounds like it might be interchangeable, but it's not. People confuse that it's the same thing. You can think of it this way: private benefit is much broader. So all inurement is private benefit, but not all private benefit is inurement. So you were organized to serve the public interest. So you have to be careful any part of your activities, whether it goes to a private individual. So let's talk about something that would be acceptable. Let's say your child or your grandchild goes to a private school. And as a grandmother, I know that they go after the grandparents for donations. And so you give donations to that school. So inadvertently, that does benefit your grandchild because they're attending that school. But it is so minimal in their whole operations, and that's not the main purpose of that donation. So that's a private benefit, very minimal, that is allowed. However, let's say that there's a school that has a scholarship fund and they're soliciting donations, and then all of the scholarships either go to major donors' children's or board members' children's or employees' children's. That's a private benefit that is not allowed. So that's kind of the difference there. You can't have minimal private benefit, but you can have private benefit that is excessive and obviously not acceptable. Inurement, on the other hand, is not allowed. And that is when a private inurement is when an insider, who would either be a board member, could be a major donor, could be the CFO or CEO, they have significant influence over your organization's activities. They enter into an agreement with your organization, and they're getting more than what they're providing back to the organization. So the example that's always given, of course, is excessive compensation to the, let's say, the executive director. They may provide 40 hours or more work a week, but they're paid excessive compensation that does not align with the activities that they're doing. So that's called inurement, and that is prohibited. And like I said, the excessive compensation is probably the example you're going to see most of the time. Now, involvement with political campaigns. This is another thing that's prohibited. You cannot have any partisan comments that are attributed to your organization. You cannot contribute to a candidate. You cannot come out and say that you're supporting a certain party on any issue. You can take positions, but you have to be very careful how they may be worded, because you don't want to, in your position, then say, I'm supporting candidate X or I'm supporting candidate Y or this party. So you have to be careful. If you are going to write a position paper, you probably want to have an attorney look at it, or someone that is very knowledgeable in this area, to make sure that you are not in any way endorsing a particular candidate. Lobbying, on the other hand, there's a certain amount of lobbying that could be allowed. So you cannot engage in what they call substantial lobbying. So of course, the next question is, well, what's substantial lobbying? Well, they won't tell you what's substantial or what's insubstantial. But if you're in this position where you are going to be doing lobbying, you can file a form. It's called a 510H form, that you can be judged by your expenditures. So in other words, based on how much funds you're expending that year, if you have a certain amount that's lobbying, you can then make it a very black and white issue and it's no longer gray. Your expenditures did not exceed the amount that was needed, therefore you're not lobbying in an excessive way. You know, we all belong to organizations probably, like I belong to the MACPA. It's a nonprofit organization, but obviously there is lobbying that's done there. For instance, every year at Annapolis, there's members there trying to keep professional services from being taxed with sales tax. So that's something that is done, but that's part of their mission and they're able to keep nonprofit status with that. And sometimes they will also say, you know, your membership fees are deductible as a business expense. However, as a charitable expense, perhaps a certain percent of it is not deductible. So the bottom line here is that if you're going to be involved in lobbying, you really need to investigate what your ins and outs are to protect yourself from running afoul of the law. Okay, so when you were granted tax exempt status, you should have received a letter from the IRS that said you're granted exempt status, and they will tell you whether you're being granted as a public charity or whether you're being granted the status as a private foundation. And we'll talk about that a little bit later. But no matter what your category of tax exempt status is, you have to file an annual filing with the IRS every year. And it is due 4.5 months after your fiscal year. And many nonprofits might have a June 30th fiscal year, so that theirs is due November 15th. If you have a calendar year, it's due May 15th. You can get an automatic extension, a 6-month extension to file. It's automatic, but you still have to file the paperwork. You don't have to give any reason, but there is still a form you have to file to get that extension. So let's talk about some of the different 990. This is the annual filing is a 990 series. And depending on the size of your organization, there are different 990 forms that may be applicable to you. And this is not if you're a private foundation, this is just if you're a public charity. The simplest one is a 990N, and that's a postcard, but they call it the postcard. It's done electronically. You sign up on the IRS website, you enter your EIN, the name, and a contact person for your organization. You certify that your receipts were 50,000 or less, and you're done. That's it. That's all you have to do. I would recommend that you also though keep records to support that you're under 50,000. We're going to talk about the fact that you always have to have good accounting records, but it makes that filing very simple. There is also no penalty if it's filed late. Whereas for the 990 and the 990EZ, there are penalties that can be substantial if they're filed late. However, the 990N, there's no penalties for late filing. You could still lose your tax exempt status if you don't file, but there are not penalties for late filing. The next easiest form is the 990EZ. And the basic criteria for being able to file that is your receipts are less than 200,000 and your assets at the end of the year are less than 500. There are some other reasons why you might not be able to do the 990EZ, but I'm just giving you the general criteria. And then if you can't qualify for the 990EZ, the regular form is the 990. And I will also say that in order to have a complete timely filing, you must also make sure that the schedules that are applicable to your organization are filed with the 990 or the 990EZ. A couple examples are Schedule A, which tells the IRS that you're still being publicly supported because you give information about your donations and charitable contributions, or Schedule B, which gives names of major donors. If you're a school, there's other schedules. So you always need to make sure that you're also filing the applicable schedules because the IRS will say it's a not complete and timely filing. If you are late, the penalties, depending on your gross receipts, can be from $20 a day up to $105 a day if you're over $1,084,000 in gross receipts. And it caps at 5% of your gross receipts, or at the very highest, $54,000. So you obviously do not want to file late 990s. Again, no penalty for the postcard being filed late, the 990N, but the 990 EZ and the 990 and the 990 PF, which is a private foundation, we haven't talked about that yet, all have substantial penalties for late filing. A 990 PF, the PF stands for private foundation, is when you are not publicly supported, but rather you are being supported from either another organization or an individual or a family. So like, Bill and Melinda Gates Foundation, obviously that's a private foundation. The funding's coming from a very wealthy individual or family, and they are, but they qualify for tax exempt status, but it's just that they have to file a different type of form. There also could be some taxes. Generally there is on net investment income tax, but it's the same dates as to when they need to be filed. And it's the same penalties if you file late. If you do not file for 3 years, and it doesn't have to be consecutive, but 3 years. So this hurts people mostly that are the smaller organizations that do the 990N. If they miss for 3 years, you will lose your exempt status. Now, that's not good, but it's not the end of the world. You can apply for reinstatement. You have a lot of work to do. You have to refile parts of the Form 1023, which is the original application that you filed. And you have to, of course, get current on all your old tax returns. So I have seen that happen with 2 different organizations where the situation is that they were smaller, obviously, because they could file the 990N, and they were relying on the volunteers. And what happened is the first person who took it on knew what to do and did it, took care of it. They leave, another person comes in to assume that role. Most of the time, it was probably the treasurer role, and they know nothing about it. They weren't told about it. They didn't know they had to do it. Next thing you know, 3 years later, the organization receives a letter that they're no longer tax exempt. So you don't want that to happen to you. So no matter how small you are, make sure that you have someone, you should have, some kind of turnover jacket so that people know what the responsibilities of these positions are. And you should also, you can probably get someone pro bono to help you out with those kind of things, just to keep you on the right track. The next thing is employment tax returns. So every business has to deal with this, including non-for-profits. So if you have employees, obviously you have to file, the withholding returns, you have to file the W-2s, the 941s, the state unemployment. And most of your bigger size organizations are going to have that outsourced to a ADP, or do it through QuickBooks, Gusto, one of the software services. And that's great. That's a good way to prevent penalties for late filing of things. It's easy to miss things. But the one thing you need to consider too, and nothing's easy anymore, everything has gotten so complicated, is you want to realize that sometimes there's additions to W-2s for fringe benefits. A common example is if you provide an employee under a group life policy, if you provide them life insurance in excess of $50,000, then some of that has to be a tax addition to their W-2. And your payroll service is not going to know those types of things. You have to tell them that, employee X needs so much added to their W-2. So you definitely want to, be aware of the payroll requirements. And again, you may want to, have an accountant or someone who's knowledgeable with payroll help you with that. The next thing is information returns. So these are also annual filings that have to be done if you pay a contractor or some type of service provider or your landlord $600 or more for services or rent. Those are some of the main examples. You don't have to pay it though if the service provider or the landlord is a corporation. So, you say, well, what about LLCs? This is where I see the biggest confusion. So limited liability companies or LLCs can be taxed as possibly a partnership, a sole proprietor, or a corporation. If they're taxed as a corporation, you don't have to provide them a 1099 at the end of the year. But if they're taxed as a partnership or a sole proprietor, you do have to give them one. And the only way you're going to know that is that before you pay any service provider, you should have them fill out a W-9, because that will give you the information that you need to properly prepare the Form 1099s. And this past year in 2020, it used to be they were all called 1099 miscellaneous forms. But now in this past year, they started with a 1099 NEC, which stood for non-employee compensation, so that your service providers, it would be reported on that form. Your rents would still go on a 1099 miscellaneous if your landlord was not a corporation. So those are just some of the more common 1099s that have to be issued. Also, as far as information returns, if you have a fundraiser that's a raffle or some type of gaming and you reach certain thresholds, you have to provide W-2Gs. And those are to report the income, the earnings that someone earned on a raffle or some kind of gaming that you did to raise funds. And I would suggest that if you do that, you always provide them the W-9 before you give them the funds for winning the raffle, because it's going to be very difficult to get that information after the fact. And then you could be penalized for not having the information to file the correct form. So then what about state filings? We talked with, all these other ones that we've talked about. We've been talking about federal forms, federal guidelines. Well, the state also has some filings that are required. And I'm just going to be talking about the state of Maryland in particular. So when you become a corporation, you get a charter with the state of Maryland. And that charter is active, but needs to be renewed every year with an annual report. So on April 15th every year, you need to file an annual report with the State Department of Assessments and Taxation. There's no filing fee. A regular corporation or a regular limited liability company has to pay $300, but nonprofit institutions do not have to pay any fee, but it is still required. And if you miss that filing, you could end up you will be not in good status with the state, and that will be on their website. And if it goes so long and you still don't file it, then you can lose your charter. Once again, it's not impossible to get it back, but it's, more fees, more time. And so you don't want that to happen. Plus, it being on the website that the organization is not in good standing isn't helpful. The other state requirement that I think there's some confusion about for non-for-profits is sales tax. Now, being a non-for-profit keeps you from paying sales tax when you purchase items. However, it doesn't prevent you from collecting sales tax if you sell items. So let's say that you have something and you sell t-shirts, or you sell plants, or you have a big fundraiser and you're selling food and alcohol. These things are taxable, and you need to collect the appropriate sales tax, and you need to remit it to the comptroller of Maryland. And I've seen where people have not understood that and did not collect the proper sales tax. And many times it can be caught by an auditor because they are aware of a fundraising event that's going on in the area, and they know that something was sold there and that you're not remitting any sales tax. I was aware of one nonprofit that actually happened to. And then there's the Secretary of State. You need to register with the Secretary of State if you're going to solicit contributions. And there's an initial registration, and then there's an annual renewal. And depending on how much you're raising in contributions, you may also have to provide a audited or reviewed financial statement. So you need to be aware of what your requirements are for your renewal. Now, the one thing, when we talked about these annual filings with the IRS, we did not talk about a 990T. And that's another form in the 990 series, and that's for unrelated business income. So you're a nonprofit, you have an exempt mission, you're doing those things. That's fine. But what if you start to venture into something that starts to compete with the commercial business down the street? So first of all, in order to be unrelated business income, it has to meet three things. It has to be regularly carried on. So an annual fundraiser would not be considered unrelated business income. It has to be something that is not substantially related to your mission. And it has to be a trade or business. So again, a trade or business regularly carried on that is not related to your mission. So one of the ones that you'll see common is a museum gift shop. So you have a museum, and let's say, we'll just say a zoo, because that's easy to talk about. And the zoo has a gift shop. Now, some of the things that they're selling in the gift shop are absolutely related to their mission, which is to educate the public about the animals at the zoo, their habitat, things of that. But some things they sell, because you'll often see like dishes, wine glasses, linens, jewelry, those are not related to their exempt purpose. And then there's other things that could or could not be. For example, they have t-shirts with giraffes on them. Well, Walmart may also sell t-shirts with giraffes on them. So you are competing with Walmart. So that could be unrelated to your mission. However, what you're allowed to do is to provide also with that t-shirt just some kind of card or information that talks about that animal's habitat, or some facts or some information that gives the buyer knowledge about that animal on the t-shirt. Then it would still be related to your mission. So you can see that it gets difficult because this is fragmented. Some things sold in the gift shop are taxable and some things are not taxable. So it becomes very important to have a great inventory system to keep track of your sales from your taxable and your non-taxable items. Another thing that there's a lot of talk about, and it may or may not be unrelated business income, is advertising and corporate sponsorships. We don't really have the time today to go into detail with that, but if you're venturing into anything that is not related directly to your exempt purpose and it's something that's going to be regularly carried on, then you need to do the research and determine, am I subject to business income tax on this part of our operations? And if you are, you file a 990T and you pay the tax. And you also have to file a Maryland corporate return and pay the tax to the state of Maryland. Now, there are some exceptions and special rules. So there's certain types of income that are just exempt. Interest, dividends, and a lot of rental income, but you'd have to be careful about the rental income because it might depend on whether the income's coming from a building that's debt financed. There's particulars there. So you'd want to look at that. But interest and dividends, absolutely. And then there's some exceptions. If your business that you're running meets these criteria, then it's not unrelated business income. And one of the biggest ones is volunteer labor. So if the business is being run entirely by volunteers, then it's not unrelated business income, and you do not have to file the return. If it's something that's for the convenience of members, for example, a cafeteria that a hospital has, it may be partly unrelated business income, but it may not be either, because it's mainly for the people that work there. And then the other thing is, if you're selling donated items like a thrift shop, thrift shops would not be considered, the income from a thrift shop would not be considered unrelated business income, because they're all donated items. And an example, like I'm involved with the Lexington Park Rotary, and we have an annual oyster festival every year up in Leonardtown. And it's done to raise funds for our purpose, but that does not exempt you from unrelated business taxable income. Just because you're trying to raise funds for your purpose, that doesn't mean anything. So, this oyster festival is done to raise funds for scholarships and for grants to charities. However, we fall out of the unrelated business taxable income for two reasons. Number one, it's run completely by volunteers. And number two, it's not regularly carried on. It's an annual event. So that's just an example of something that an organization does that is unrelated to their mission, but falls out of that UBIT. That's what they call this, UBIT, unrelated business income tax. Okay, let's also now talk about some best practices. Now, these items that are listed here do not have anything. You will not lose your exempt purpose, your exempt status, if you don't comply with these things. But this is just some information to set yourself aside. At some time in your life cycle, you may want to become accredited with some organization, or there may be grants that you want to apply for, and they may ask these questions, and you'll be judged on a higher scale if you have these things. So these are things that, again, they're best practices. You won't lose your exempt status if you don't do it, but it's things that we encourage. And as a matter of fact, many of these are actually questions on the Form 990. Do you have a written whistleblower policy? Do you have a written document retention and destruction policy? So you want to be able to, it's not, again, you're not going to lose your exempt status if you answer no, but it does put you in I think, a better light. But let's talk in the beginning about an effective independent board. As you see so many nonprofits coming up, even in the St. Mary's County community, there's always new nonprofits, and it gets hard to get effective board members. So what I recommend to people is that especially when you're starting out, but even as your organization evolves, you'll have to probably look at this a little bit differently. You want to think strategically. Who do I want on my board? What are going to be the best individuals to have on my board? Because they play a significant role in contributing to the organization's culture, to the strategic focus, to its financial sustainability, and absolutely they're ambassadors in the community for you. So you want to think, what type of individuals do we want on the board? And then there's like three primary duties that we want to think about for board members. There's a duty of care. they want to ensure the prudent use of all of your organization's assets, and not just your hard assets, but your personnel and your goodwill in the community. And then there's a duty of loyalty. So first and foremost, this is the most important thing. Are you promoting the nonprofit's activities over your own self-interest or over the self-interest of a very good friend of yours? For example, you might be on the board, you might be going out to bid for a building, and your very good friend is a contractor, but you have to be able to either, remove yourself from that boat or be able to look at it objectively to what is in this organization's best interest, this bid or it could be another bid. And then there's a duty of obedience, which is kind of a strange word, but it's to make sure you comply with all these laws that we've just been talking about. Because as soon as you don't, things start happening that aren't good for the organization and for the organization's reputation. So I can't stress enough how important board members are to the success of your organization, and taking the time and the strategic planning to make those types of decisions. And even, our organization, we're a CPA firm, we do that same thing with who's going to sit on our executive committee team. I mean, very different than a nonprofit, but still, it's very important for the strategic planning of any organization to have the right people sitting on these boards. The next thing is, please, please, please keep minutes of all your meetings. Especially, coming from an auditor standpoint, that's one of our required audit procedures, because you can say Joe Smith was supposed to be paid this much in a bonus, let's just say, and it's on the books, but there's nothing in the meeting minutes to approve that. Or, we entered into this agreement with XYZ company and we're paying them, $100,000 a year. Well, you need to have these things documented in meeting minutes. They need to be approved by the board at the following meeting, and they need to be, and the approvals need to be noted. Let's talk about a written conflict of interest policy. So when you think of conflict of interest, a lot of times, at least I do, I think about it from a financial standpoint. I don't want to have a financial conflict. I don't want to do business with this company if I have an interest in that company. But it's not only financial. It's also, the policy should also talk about, how do you handle board member conflicts? What's the processes you're going to follow? What happens if you violate a policy? So you want to have it to be general, think about what kind of conflicts could happen between your board in the community, a board member in the community, and also there's financial concerns too, that the board members should not have financial conflicts of interest. But those are the types of things that you want to think about with a conflict of interest policy. The next policy is the whistleblower policy. And this probably became more prevalent after there was, different fraud issues that came to light years ago with, like, Enron was one of the big ones. But even with nonprofit institutions that were paying excessive compensation. But the whistleblower policy then became very popular, where someone who knows that something is happening in a way that it should not be happening, and this could be a harassment issue, this could be theft, it could be, fraud with the public, it could be anything that someone knows is not proper. And it should say what the chain is for them to report this impropriety and what are their protections for doing that. The next policy is written document retention and destruction policy. This is very important for all businesses. There are certain things, Sam talked about your need to keep good records. There are certain things that should be kept forever. For instance, your letter from the IRS that says you've been granted nonprofit status. I mean, that should be kept forever. your articles of incorporation, your bylaws. Those are what we call permanent documents. And then you have things like leases that you want to keep, obviously, while you're still subject to the lease, but even so many years after. And then, of course, your accounting records. There's certain things, canceled checks you keep for so long, bank statements you keep for so long. But again, because of turnover in an organization, you want to have these things written so that when someone replaces someone else, it's not a mystery to how long we should keep things and they don't start throwing out things that they shouldn't. So it's very important that this be a written document.
Marianne, I had a question I put in the chat.
Okay.
I know partial answer. Can anyone ask to see these types of policies? Like, for example, an organization will say they have them and their board has signed them, but they don't exist. You can't find them on the website. And, can anyone say, hey, I'd love to see?
I don't, that's a good question. I don't know 100%, Kara, but I don't believe so. There are certain things that are available for public inspection, and we'll talk about that on the next slide, actually. But those are internal things that I do not believe you have to show, but I would check with your attorney for sure. But I don't believe, I'm not aware that you have to give those to anyone.
I do know there's GuideStar. I'm not sure if you're familiar with it.
Yes.
Yeah, okay. So on there, an organization can go in and claim their listing, and it will ask them, do you have a whistleblower policy? And you can actually share a copy of it in the interest of transparency. So the more you can do transparent, the better.
Yes. And yes, GuideStar is a very good resource for the public. And obviously your 990s get posted there, and on there would be your answers to those questions. So, I mean, it's not something that I think is bad to share, but I don't think you necessarily have to, but I agree with you. It's transparency.
Yeah, the more transparent, the better.
Yeah, I agree.
Okay, I was just curious about that. Thank you.
And then the last thing I have on here is the written documentation for your determination of top management compensation. So some organizations, especially bigger ones, will have a compensation committee from their board. But whether you have that or not, there should be clear documentation, because this is a hot issue on your 990, is what is your top individuals being paid from the organization and from related organizations. So you might, have a sister organization that's another nonprofit, and an employee X gets so much from you and so much from them, and that's going to end up being disclosed. So you need to have really good documentation on how these are determined. How often, what's the criteria, if something some organizations call scorecards, like, here's your scorecard, this is what we think you should achieve this year. And then, you go back and you talk about how well they did on those items on that scorecard. So that's very important to have written documentation of those things. I can't emphasize enough how much written documentation can help an organization. May come back in a lawsuit, like, Sam was stressing, but from an audit standpoint, for grants, for any issue that might arise where there's a conflict about what happened or didn't happen, nothing can beat written documentation. So I really do emphasize that for all nonprofits. And then Kara was just asking about, what must you have for public inspection? Well, there are things, and you have to disclose this on the 992. You have to have available to the public your exemption application, which was, could be, I don't know how many years ago. If you've been a nonprofit for 40 years, it might be from 40 years ago. Your annual return, which is your 990, and your 990T, which is related to your unrelated business taxable income, if that applies to you. Now, I will tell you that on the 990, there's a schedule where you list your top contributors if they reach a certain threshold. And you not only list their name, you list their name, address, and the amount they gave. So in this public inspection requirement, that should be redacted. So like our clients, we give them a copy for their files, and then we give them a copy that's for public inspection, which has those things redacted, because that is not for the public to see. And you have to agree to let someone see it. It doesn't have to be that they walk in off the street and you say, oh yeah, here it is. It has to be, they call, you set up an appropriate time, but you do have to let them be able to see those documents. I skipped down, but the one thing that's very important, and it's important to keep your exempt status, are you operating in accordance with your original application? So, back when you decided to become a nonprofit, maybe you were going to be helping the homeless, and that was your mission. And then it's evolved, and you've helping veterans that are homeless, or you're helping families with other issues. The point is, every organization is going to evolve, and is that still operating in accordance with your application? Well, some of those, like, if you were going to help the homeless and it goes to, we have more of an emphasis on veterans, that's still helping the homeless. You maybe don't have to disclose that, but I will say I would be more transparent with the IRS with any changes. And it's just putting it on your 990, what new activities you've taken. And obviously, if it's something that's way out in left field that has nothing to do, if you're going to start selling art when you started out to be a homeless organization, that obviously needs disclosed. But an organization evolves. So what you originally wrote in your application probably is going to change somewhat, probably get broader as you go on. And so I would just say, if you have a question, should I disclose? Disclose. It's not going to hurt you. It's more transparency, and I think it's good to go in that manner rather than to worry about it and not disclose it. That doesn't really make sense. And I believe this is the last thing I had today was your acknowledgments for charitable contributions. Again, this is a law, what you need to do. It's more that you're going to hurt the person that donated if you don't do it than hurting yourself. Because for an individual to take a charitable contribution, if they gave over $250, they cannot rely on a canceled check if they're audited. They have to have a letter from the organization, and the letter must have certain things on it. It must have the name of the donor, how much they gave, the date of the donation, and most importantly, it must say that no goods or services were provided in exchange for this donation. And I have seen some letters that didn't have that on there, and it's very important. And again, it's to protect your donor if they're audited. And you want to do that. And every donor wants to be acknowledged. So some people do it for any amount, but you do have to do it at least if it's $250. And then the other thing that's common is quid pro quo contribution. And a good example of this is a dinner. So, you're a school and you're having a dinner, and it's $100 a ticket, and you give the $100. The organization's responsibility is to say, thank you for purchasing these $100 tickets. It fulfills our purpose. You write a nice letter, and then you have to say on there, please be aware that $75 of this donation is tax deductible, because they have come up with the formula or the cost that it was actually $25, the cost of the dinner, and the tickets were $100. Therefore, you're going to get a donation for $75. So those are important that you provide those. And what isn't on here, but I thought of later, is if someone donates, let's say a piece of art or some other something that they want to give you a tangible item as a donation. You should thank them for that tangible item. You should describe it in whatever detail you can, but you do not provide the value for them. They provide the value themselves. And then it's up to them to support it if they would be audited. Now, obviously, if somebody gives you something greater than $5,000, then they have to get an appraisal, and that's a whole different situation. But if they're giving you things up to $5,000, meaning tangible items, then it is not your responsibility to value them. It's up to the individual who's providing that donation to value that. So it was a lot of information. It's just trying to make sure that you protect the asset of your reputation and keeping your organization in good standing with both the feds and the states. Here's my email and my phone number, my direct line. If any questions, please feel free to reach out. I'd be happy to help. Is there any questions, Kara?
I don't see any in the chat,
Okay.
but if anyone does have a question at the moment, feel free. But you've provided your contact info, so.
Yeah, I did. And so thank you very much.
Yeah, well, thank you, Marianne. This is really good information and appreciate it a lot. And I think what we'll do is we'll take another 5-minute break. If that works for everyone. Go refill coffee if you're still doing coffee. Hit the restroom or what have you, and we'll come back at about 11:06. Does that work for everyone?
Yep.
Cool, great, thank you. Okay, so next up we have Dan Burris, and he's going to talk to us about insurance issues and topics. And just let me know when you need me to share the screen, Dan.
Okay, Kara, thank you very much. There's one thing I wanted to kind of mention just after the first two, unfortunately I have to follow them because they are both very, very good at what they do. Sam had talked about the liability nonprofits having the exemption, but also just remember that the liability insurance includes the defense costs, which can be very high, which Sam had talked about also. But that doesn't mean, even though you're exempt, doesn't mean that you're not subject to a lawsuit at any time. So just going to kind of remind people that it does include the defense costs. So. Okay, we'll get started with my, if you want to put up the Ultraflex policy declaration page. Well, while she's doing that, I'll just give you a little background here. It's a current policy that we have in place for a nonprofit. So I just thought I'd go over the coverages that we've currently have with this this group. I'll go ahead and kind of start on some of the things that, of course, you've got business personal property. Since this company this nonprofit actually just leases the space, or we just have personal property coverages for them.
Is this the correct one?
Yeah, yes,
Okay.
ma'am.
Great.
Just wondering, can we make it a little larger so people can see? Okay. What I was talking about is the, okay, yes. The business personal property of the nonprofit is included in here. There's no building coverage because they don't own the building that they're in. But then we go to the liability, as you can see there. You know what? I'm sorry, that's the workers' comp policy, not the package policy. Can you put? Okay, this particular instance, they've got business personal property at like 25,000. They don't have a lot of assets. There are no buildings. Income protection is included on all general or package policies. In this case, it probably doesn't really, for the nonprofit, you're doing all the work outside, and you can also, can always get another office space. So, but let's move, we'll talk about liability mainly. In this instance, it's 1 million per occurrence and 2 million aggregate, where you see the general aggregate limit. That means you can have 2 $1 million claims in 1 year. Aggregate means per year. So you've got damage to premises rented to you. Say you are renting a space and you do something that causes damage to that space. This would give you coverage for that also. And the medical expense limit of $5,000. That's if somebody gets injured on the premise and you're at fault. Well, you don't even have to be at fault for that. Say if someone trips and you just want to cover your cover their hospital visit or something, you can pay up to $5,000 for that. You don't have to be liable for that. And then the personal and advertising injury limits, say you do advertising for your nonprofit, and you come up with something wrong, someone sues you because of that, there is coverage under here also. Then next would be the products completed operations. That really is not necessarily for nonprofits, although if there's a nonprofit that sold products, say if you put together a product for spices and you sell them and someone got sick from that spice or you did it incorrectly, there's coverage for that also. Go down to the next page if you would. There you go. Some of the optional coverages, employment practices liability. That's certainly something that, if you hire someone or do something to an employee, that's certainly needed coverage with all businesses, not just nonprofits, if you do have employees. So this is an aggregate limit of $100,000 for that coverage. Now you do have a deductible there of $2,500 per loss also. And that's, it's based obviously on the number of employees that you have and the liability across the board. The other thing I wanted to mention is non-owned and hired auto liability, $1 million coverage there per person. What that is say you've got a employee or a director that uses their personal vehicle on the job for the nonprofit. Say you're going to the bank or going to the post office or doing anything on company time, and they have a auto accident in their personal vehicle. Any business, or not in this case, a nonprofit, could be brought into a lawsuit. So you've got to make sure you've got that coverage there also. And the bodily injury is if the injuries, of course, and then property damage is damage to other property. One other area that may need to be added is the additional insured. Say, for example, if you're leasing a place, your landlord is going to want to be named as an additional insured if they are brought into a lawsuit that someone got injured on, say, on their property, but you were the ones that caused the damage. So if there's a lawsuit, everyone's going to be named. So you just need to make sure you've got everyone properly covered. So the main thing, of course, is the directors and officers liability for nonprofit organizations. That's if the board of directors make a decision and they've got something in effect and then it damages someone else, that can be a lawsuit can certainly be brought against the directors and officers. So, and for nonprofits, most companies, insurance companies, will include this. For example, if you're not a nonprofit, for example, with myself, I've got errors and omissions coverage. Same with Marianne and Sam would have the same type of coverages, but we have to go out to excess surplus lines carrier that specializes in that. But because of the exemptions, standard companies will collect or will include the directors and officers liability. And then one other thing also is employment practices liability. If you have employees and you decide to fire someone and they disagree with that, they can certainly bring a lawsuit against you. There's one that we're dealing with right now that the directors actually fired the the director of the nonprofit, and so there's a lawsuit going on there. So I mean, I like I said, this is a lot to cover quickly, but that's kind of what I had as far as the package policy goes. Does anybody have any questions on that? That page there does show the amount of personal property of 25,000. That's about all that's showing there. Okay, if there's no questions on the liability or the package policy, why don't we move over to the workers' comp policy then? There we go. And of course, this, the bodily injury and property or bodily injury by accident, the state requirements are the 100,000 each accident, bodily injury by disease 500,000, and bodily injury by disease 100,000 each employee. Again, those are if somebody gets injured on the job that are employees, then you've got to have the workers' comp policy in place. Now, we do also have an umbrella policy on top of both of these policies, which gives an additional $1 million limit over and above the primary policies of both the liability and the workers' comp. So, and workers' comp, of course, is based on payroll. You want to pull that down a little bit, please? And most nonprofits are clerical office employees, and the rate per $100 of the payroll is what the premium is based on. Now, if you've got someone that's doing construction work, that's quite expensive. You're talking $8 or $9 per $100 of payroll. So, and as you can see here, the salesperson's outside is a little higher than the office employees, but again, this needs to be in place, and in case any of the employees are injured on the job. So. I know this is pretty quick, but anyone have any questions on either one of these packages? Okay. Kara, that's pretty much my program that I wanted to talk about. I know it's a lot quicker than the first two, but
That's okay.
and if anyone has any questions, please contact me. It's Dan Burris at danburris.com.
Yeah, so I could speak to the director's coverage. Was it the
Okay.
DO? I was involved with an organization a number of years ago. We were just a bunch of parents running a sports club, and we had an embezzlement. And, what did we know? We were running a nonprofit, but we really didn't know much. And it turned out we were part of a larger national organization, and lucky us, we had this director's coverage because we were very concerned that parents in this sports club, would be upset with the board for not doing proper judiciary, oversight. I'm not judiciary, financial oversight. And we were very grateful to realize that we had that coverage. But that's a bad way to operate, not knowing you have it or not until it's, almost too late. And lucky for us, nobody did sue us.
Yeah.
It's something that a lot of folks just, they think, okay, we've got the basic insurance that we need, and they don't realize they need that.
Yeah, and I did have a note here to mention employee dishonesty, and that's what you're talking about. That's where the coverage comes from. It's normally a bond amount and for the comptroller, for example. your
Yeah.
bookkeeper would have a set amount that the company would pay up to for
Right.
embezzlement, things like
Well, it
that.
was our bookkeeper who did the embezzling.
Yes, exactly. So, yeah, and, you ought to have in place, say for check writing, you've got to have 2 signatures rather than just 1 signature, something to consider.
Right, and we didn't have that. And lo and behold, at the time, there was a nonprofit institute class
Okay,
about these things. And so we did put that 2 signature thing in place. And I remember meeting somebody, the new treasurer in a parking lot somewhere in Waldorf to sign a check, and then he would go meet the other person to sign, but the treasurer was not allowed to sign. It was 2 other members.
right.
Really worked out well.
Yep.
But what did we know? Just a bunch of silly parents, running a $500,000.
Exactly. So,
Yeah. But does anybody else have any questions or from boots on the ground stories, or Mary Ann is still with us too?
Mary Ann, do you have anything you can add to the monetary side?
You mean embezzlement?
Well,
Yeah, I mean,
controlling that, yes.
yes. It's so interesting because from an audit standpoint, and you need to have segregation of duties, and that's what those 2 signatures on checks amounts to, is a segregation of duty. Because I have seen, and not with nonprofits, but 2 businesses recently who have experienced theft. And unfortunately, and it's very sad, it was a longtime bookkeeper who they felt was part of the family. And I think then your guard goes down because you trust this person so much. And then for whatever reason, did something go bad in their life or whatever, they felt that they were entitled. And they both had kind of creative ways that they did it. Not really creative, to be honest with you, it was pretty basic. But because there was no segregation of duties in those companies, and the owners kind of said, I'll let so-and-so take care of these things, there was theft. And it was very sad and hard for everybody, especially because these people were so trusted by the owners. But just simple things like, if you're going to have the same person who's writing your checks do the bank reconciliation, you better be looking at that bank reconciliation and make sure you know what's going through your bank account. So, that's very important. And the other thing that we didn't talk about are investment portfolios. I think this doesn't apply to all organizations, but if you have any type of investment portfolio, you need to be very comfortable with how it's being managed, and make sure that it's being managed in a prudent you're a fiduciary of these assets, and it has to be managed in a very prudent way. You can't just say, boy, I want to go into Bitcoin. You have to be very careful with any type of investment. A lot of these could be endowments even, and you have to be, you have a responsibility to the people that donated that money. So, a lot of nonprofits have separate investment committees that oversee this. And, most of the time these are given to a broker or an organization, like an Edward Jones or a Merrill Lynch, and there's an advisor there for the company or for the organization. But you need to also, your board needs to understand what that person's doing for the organization and how they're managing those funds, because in the end, you're responsible. So.
And I see Randy put up here, it's necessary to have cyber insurance, which is certainly this day and age, as we can see in the last few weeks with the gas situation across the country. Everyone needs cyber security coverage, and most companies can add that to your policies. There's so many endorsements that you can add to your policies most package policies have a limited amount of coverage, but you can also increase those amounts also. Okay. Any other questions?
Yeah, someone is asking, can you address the cyber coverage? What types of things would it cover? Ransomware hacks, anything else?
Yeah, yes, I can actually send out an endorsement to you that shows all the coverages. I don't have that up right now, but I certainly can send that out to you to give you that background.
Okay, send that to me, and when I send the follow-up to everybody in the
Yeah,
class, I could
certainly.
include that. Mhm.
Yep.
So Dan, I remember this is probably 6 or 7 years ago, we tried to get cyber insurance, additional. And it was very difficult because you had to make sure that like your employees' phones couldn't, there was you had to have all these authentication things. And so I guess that's still the case. You have to have all kind of safeguards in place.
Well, it's depends on the type of business also.
Okay.
So especially in your case, yes, definitely.
Yeah, right. Okay.
I have a quick question, and it's too complicated to type, even though it's a quick question. But so I think this is probably directed toward Marianne. But when you were talking about sort of the practices that a nonprofit would use to try to ensure at least that the money is being managed carefully and that you reduce your risk of embezzlement and that sort of thing, are you saying that you need to have within the agency, you need to have the separation, or can you do it? For instance, this is what's occurring to me. So, we write the checks within the agency, but we have the reconciliation done by an accountant monthly. So we don't have somebody inside who's separate from the check writer doing the reconciliation, but we have it done by an independent person.
That is certainly helpful. You would still probably want, though, just for someone in-house to look at the charges that are coming through on your bank statement, because the outside person, while they may know a lot, and obviously that's a wonderful procedure to have in place, you probably still want, like, the executive director just to look quickly at who the vendors are that are being paid and that there's no unusual names. Similarly, look at, an employee run, when your checks go out, or, direct deposit goes out for your payroll. Just look at that employee run and make sure there's no names there that you don't have any idea who that person is. And those don't take long. Those are just very quick things for you to do. But obviously having an outside independent party do that is wonderful practice. Good idea.
This is Lydia. I do have a question as well. One of the contracts that we have from the state of Maryland, from one of the agencies, it requires us to maintain a minimum. And the way it's worded is the contractor shall maintain crime insurance to cover employee theft with minimum single loss limit of $1 million per loss and a single loss retention not to exceed 10,000. So is that referring to the embezzlement, to the employee dishonesty? The term crime insurance is just, I wasn't sure if it was the same thing.
Yes, pretty much the same thing. Yes, ma'am.
Okay, well, the limit is like $1 million. We don't even have $1 million to steal. So how can we go around that as far as negotiating with the state a lower limit? Would that require something from our insurance agent to certify that we do not have that many assets, or what is the process?
I was going to say, I would talk to your agent about that and send the requirements from the state to the agent so we can investigate it and talk to the company about it.
Okay.
Okay.
But it's crime insurance refers to that employee dishonesty, the embezzlement issues and things like that.
Correct. But I'd like to see the actual verbiage from the state to be able to answer that properly.
Right. Yeah, that's what it states, the thing I just read, that they require us to have crime insurance to cover employee theft with minimum single loss limit of $1 million per loss.
Yeah,
And that we
yes,
don't
yes.
have that much money.
Yeah,
We don't even have half of that.
Employee theft would be the employee dishonesty, yes.
Right. Okay. Okay. So it's a matter of negotiating with the state limit and then making sure we have that coverage. Is it standard for nonprofits to have that kind of coverage into their package?
Yes, yeah.
The liability?
Correct.
Okay. What are the limits that you see for like a small nonprofit?
I mean, it's, I'd have to double check that. I will make a note to double check that for you also. And get that to.
This is Rosanna. Mr. Dan, I think that one of the things, it's important to have insurance. One of my friends says it's more important to have insurance than to actually buy bread. But most of the time, it's really not that expensive to carry the coverages that are required. Our nonprofit does a lot of events, and I want to ask about coverage. They're always asking about what would that be called when it's terrorist coverage, and I usually decline that, but I'm wondering more with all of the activity that we've seen in the last year and a half, if it might be something that's important to have.
Yes, that's very inexpensive, the terrorist coverage. Yeah, it's, that's really included in a regular package policy. But when you go out to excess lines carriers for special events like that, then that it's a little more, but it's like 3%. It's not very expensive at all.
Right. Well, that's what I think if she looked into it, Lydia might find out that it's not too bad. One of my experiences with coverage, we've done events for years and years and years, and we decided they're honoring events, commemoration events for, in this area for World War II, the historical, things that are happening with regard to World War II. And we decided to add it actually was a very small motorcade parade from Pax River Museum around to Solomon's. And the original events carrier that we've had for 20 years declined to cover us for the motorcade. So we had to scramble and find event insurance because I'm personally very risk adverse. And I didn't want to, take the chance of having a motorcade and somebody getting an accident, even if it was the other people's fault. It's just not worth it, Sure. So that was an insurance problem that we ran into. We did find someone to cover us, but we had to scramble because we found it out like a week before the event that the carrier was not going to cover that. Anything with wheels on the road, you have to make sure that any little nuance, you need to make sure with your carrier that they will take care of you.
Yes, and event insurance is, you go through a brokerage firms to get that. It's not your standard carrier that would cover that you've got your regular liability with for a major event like that. But yes, it is available through excess surplus lines carriers.
Right. Well, and what I guess I'm also encouraging those who are new to the nonprofit world is to not be afraid to do whatever it is that you want to do. There is somebody who will help you to get where you need to get. And, so anyway.
Yes. And that's, talk to your insurance agent broker. So, yes.
Great. Well, if there's nothing else, we could wrap up early. It's Not a horrible thing, is it? Information for a couple of hours. But what we'll do is, like I said, we'll send a follow-up email with the presentations and the documents. And Dan, you'll send me some more info,
Sure.
and I'll include that.
Yep.
And we do have a class evaluation, and we'd love it if people could fill that out and get it back to us. As well as if you're with the St. Mary's County nonprofit and you need a certificate for having attended this class, just reply to my email, let me know, and I'll get you that. That's if you apply for St. Mary's County annual grants, not the relief grants, the annual grants, and it comes up again in January, I believe. And just while I have your attention, the Nonprofit Institute has a survey out through our newsletter, and we sent out a reminder the other day. We would love it if you could fill it out. It should take less than 10 minutes, and it really helps inform what we're going to be doing going forward, because as we all know, the whole world has changed. And so we're reevaluating everything and moving forward, and we love input from the folks we help, and that's all the nonprofits. So please fill out that survey when you get a moment. And also the state Maryland Recovery Now funds, you probably know, probably some of you have already applied in St. Mary's County. It is open to apply. It's through June 7th. It is super simple and easy. Not a lot of requirements. You just have to be, I forget the exact details, but it's very simple to apply. And however many nonprofits apply, they're going to split the 300,000 something evenly among all. And if you're in St. Mary's, you're lucky because it's not open in Calvert or Charles yet. In fact, there is a meeting today at 1 o'clock with Maryland nonprofits about that with the folks from the state who are running that program. So if you're in St. Mary's, go for it. They had 14 applications after 2 weeks of having it open, and they asked us to help spread the word to please apply for that. It's relief funds, so everybody can use that. So with that, if there's nothing else, I guess we could just wrap it up, and hopefully you found this helpful. I think a few of you did. Someone, Laura, you mentioned in the chat you did. That's great. And I just want to thank Dan and Mary Ann and Sam again for taking their time to share their insights and knowledge with us, because it's really important. Appreciate it.